60 Minutes with Angela starts right now.
Opportunities are shrinking for our people. Power elites are grabbing all the resources, including lands and all that. And so people are out there, the unemployment rate is high, schools have been destroyed, healthcare delivery system is comatose, social provision is nothing. So our people are going to all the remotest part of the world to look for education, Ukraine, Georgia, all over the place to look for education, even places like Ghana and Togo, we are going there to look for education. Our people are dying in India, all sorts of problems. So the state cannot perform the function of a vibrant and beneficial state.
Well, hello and welcome. This is 60 Minutes with me, Angela Ajetomobi. Thank you for joining me on the program today. And so it's that time of the month again, our monthly look at what the law says as far as it concerns politics and current affairs here in the Federal Republic of Nigeria. There are always legal issues to examine, explain, and clarify. My host today is JITI OgUNYE, Principal Partner, JITI OGUNYE & Co. Legal Practitioners. So, join me after the break as I count down 60 minutes with JITI OGUNYE, who will be answering the question, what exactly does the law say? Welcome back. And welcome, Mr. OgUNYE. Thank you very much for coming on the program.
Thanks so much for inviting me. The pleasure is mine.
So before we start, I will give viewers a little bit of background on Abia State, one of the 5 states in Nigeria's southeast geopolitical zone. It was created on the 27th day of August 1991, created out of the former Imo State, which also still exists. Its capital is Umuahia, and it has a landmass of 6,320 kilometers. On the 27th day of June 2016, the Federal High Court in Abuja, Nigeria's Federal Capital Territory, sacked the governor, Okezie Ikpeazu, from office as governor. The court held that he had submitted fraudulent tax documents among papers he filed with the Independent National Electoral Commission to run for the governorship election in December 2014. So, Mr. OgUNYE, did you agree with that judgment? I'm looking at this now, the case since December 2014. This is July 2016. Does it make sense 2 years on to remove the governor at this time?
As lawyers and non-lawyers, we cannot discuss ongoing cases in the judiciary as if we are predetermining the outcome, acting as a closet judex, discussing the merits and demerits of the matter and telling the public how the case will eventually turn.
Yes.
However, being a matter of public interest, we are permitted to discuss certain aspects of the matter for the enlightenment and information of the general public.
Okay.
Now, because of what I've said as a prefatory statement, I won't discuss the merits and the merits of that case.
Right.
Suffice it to say that a pre-election matter can drag for some time before it's eventually resolved. And what is interesting to note is that unlike an election petition, which under the Electoral Act is timed in terms of its resolution,
yes,
a pre-election matter is not timed.
What constitutes a pre-election matter?
A pre-election matter which is taken to either the High Court or the Federal High Court essentially is a matter that is challenging where the qualification of a candidate in an election out of a troubled primaries usually is challenged. An election is yet to be held.
Right.
And so it's not a petition. It's not an election petition challenging the outcome of an election.
Okay.
It is a matter, a suit, challenging the selection or the election of a candidate in an election who is poised to stand for that election. And once the matter is lodged in the court, regardless of when it's eventually resolved, even after an election has been conducted and a winner has been sworn in, it is still, called or regarded a pre-election matter. Okay. And so it goes to court, as I said, and is decided by the court. So, and I've made the point that unlike an election petition that must be lodged 21 days after the certificate of return is given, or after a declaration of election is made known, and then decided 180 days in the tribunal of first instance, then 60 days, and then 60 days. A pre-election matter has no such timeline. So it's regarded as a usual or a regular civil suit in a court. Okay, so it can take some time before its resolution. The only thing is that our courts are usually sensitive to the fact that this is a pre-election matter and it ought to be decided timelessly, so that it's not just there while the mandate of the person is running almost up to the end of the tenure before its resolution.
So those who were quarreling with the fact that this was a federal high court, I heard a lot of people saying, what concerns the federal high court or a high court in an election matter? This would explain why the matter is in the federal high court.
Exactly. As a matter of fact, if pre-election matter is taken to a tribunal, then it will be thrown out. It will be struck out immediately, because the tribunal and election tribunal will not have jurisdiction to dabble into a pre-election matter. In the same vein, if an election petition is taken to a high court or a federal high court, it will similarly be thrown out, because the federal high court will not have any jurisdiction, that special jurisdiction, to determine an election petition. So that's how it works.
We've heard the governor of the state, Governor Ipeazu, say that democracy is on trial in Abia State. I think he was reacting to the order to issue a certificate of return immediately to the rival. Is that normal when the court orders something? Is it normal for it to be effected even if one party says, I have appealed?
Does the Federal High Court have the jurisdiction to sit over the matter? Yes. And Dr. Ipeazu, the governor of Abia State, is not contesting the jurisdiction of the Federal High Court to sit over the matter. So when a court delivers a judgment, does the court have the power to give an order that forthwith, that's the language of a judgment usually, forthwith, that something be done. So the court in this instance had the power to direct INEC to issue a certificate of return to Dr. Oga immediately, and to also order that Dr. Oga be sworn in. Now, that said, once that judgment was delivered, what was expected of Dr. Ipeazu? If he was dissatisfied with the order or the judgment of the court, he will file a notice of appeal and a motion for stay of execution of the judgment.
That's two things.
Yes, two things. A notice of appeal without more does not operate as a stay of execution of judgment. The fact that you are expressing your dissatisfaction with the judgment does not mean that you shouldn't comply with the judgment. You have to file a motion for stay of execution of the judgment, because Section 287 of the Constitution is a special provision of the Constitution and enjoins that once the judgment of court is pronounced, all authorities and persons must comply with that judgment.
All authorities and persons.
Technically, INEC will say that it's just merely complying with the order of the court.
Yes.
Now, there has been a contention and a controversy as to when INEC received a notice of appeal and when he didn't receive a notice of appeal. But eventually that matter was resolved when INEC said that yes, he received a notice of appeal, a department of his, a legal department received a notice of appeal. That's neither here nor there. That meant that INEC indeed received that notice of appeal.
Yes.
But did INEC also receive a motion for stay of execution of the judgment. I wouldn't know. Nobody has said that INEC actually received that. Though, in the eye of some people and commentators, was hasty in complying with that judgment, particularly when INEC has not been known to be very diligent in even performing its primary functions, conducting elections, staggering elections and all that. So people might say that INEC was mischievous, but the point is that INEC was merely complying with the order of the court. Now, if a notice of appeal coupled with an application for stay of execution are filed and served on the parties, regardless of the fact that that application for stay is yet to be granted, matters ought to remain in status quo.
What will be the status quo in this respect?
The status quo will be that Dr. Ekpeasu is still the governor. Oga has not been sworn in. INEC has issued a certificate of return. That certificate of return will be in the hand of Dr. Oga, and then wait for the resolution of the matter by the court. And I think that was what the Attorney General of the Federation did 2 days ago, when he said that parties should wait for the outcome of the matter in the court of law, because a lot of people are suggesting that the Attorney General should give directives, should give advice to the federal government on how policemen are going to be deployed, security agencies, to enforce the judgment of the court. And the Attorney General said no. So let parties wait for the outcome of the matter. So the point is that once those two processes are filed and served on the parties, you are not expected to then post haste impatiently, then say that this order of court, this judgment of court must be enforced at all costs. So at that point, that motion for stay of execution will first be decided by the court that gave that judgment. It's like that same court reviewing its own judgment. I've granted the judgment. I've directed that it be executed immediately. Now you are saying you are dissatisfied with it, and you want a court where 3 heads are better than one to have a fresh look at this matter. No problem. But in the meanwhile, you then brought an application for stay that you stay the execution of my order so that it will not be enforced against you, and that you will not be able to return to the status quo. Now, I've looked at it. I see no reason why I should stay the execution of my judgment. Oh, I see a reason why I should stay the execution of my judgment. That court will decide that. Immediately the court decides that, one way or the other, the party who is dissatisfied still, in this case, usually the party who is bringing the application for stay of execution will replicate immediately, without leaving a gap, replicate the same application for stay before the Court of Appeal. So that the Court of Appeal, acting under the Court of Appeal Act, Section 17 of that Act, can then exercise its power to grant stay of execution of judgment. In the meanwhile, while that application is pending, also in the Court of Appeal, until it is decided one way or the other, parties are not expected to execute that judgment, because doing so will be foisting a fait accompli on the court that is yet to decide the matter. And judicial powers are special powers. So once the matters have been submitted to the court, you have to allow the court to determine the matter. Now, I've had a lot of people say that, oh, this judgment is a declaratory judgment. It's not an executory judgment. That being so, it is self-enforcing. I say, okay, that may be so. I'm not a lawyer in the matter, but the little law that I know says that if you say that it's a declaratory judgment, why then are you directing somebody to do something? It's a judgment that specifically directed that certain things be done, certain steps be done. These are mandatory orders granted by the court. You could say that they are consequential orders and that they are not part of the relief sought. But the point is that that judgment has directed that something be done, that judgment be executed. And so, for me, whether it is a declaratory judgment or executory judgment, once the matter is submitted to the court, all of us have to wait for the final resolution of the matter. You know, sometimes politicians are always in a hurry to grab power, but paradoxically they are not in a hurry to deliver on their promises. And so, even after they spend 4 years in office, they then tell you, oh, we couldn't exhaust all we wanted to do. We need another 4 years. Now, the wheel of justice, we're told, grinds slowly but surely. By the authority of Obi and INEC, the tenure of a governor does not start to run until he's sworn into office. So even if the polity in Abia State is not heated up, and parties allow the matter to go throughout the entire gamut of the judiciary, so that the Supreme Court eventually then decides on the matter, just as it happened in the Ameshi's case. If Dr. Olga is the eventual winner, his tenure will start running, after that pronouncement. He will still have his 4 years. So his mandate is not being looted, so to speak. The losers, unfortunately, will be other state people who will have been governed for some time by Dr. Ikpeazu. And so the saber-rattling, the controversy, the agitation is really not necessary.
Needless.
It's needless in my view.
Yeah.
And so let the parties wait for what the court will decide. If the Court of Appeal, for example, is of the view that judgment ought to have been executed, the Court of Appeal will also say so. And that will also make Dr. Ikpeazu's case more untenable and all that. So I think that when matters break up like this, because there's also another second leg to it, another contestant in the primary, also has an action in another high court, or somewhere around that place. And so he's also saying that he should be the beneficiary of the nullification of the election of Dr. Ikpeazu and all that. When matters break up like this, lay people usually give the judiciary a heavy knock, give lawyers a heavy knock.
Yes.
They are the people who destroy the society and all that. I don't think so. So you can have that kind of, but eventually, as matters go up in the judicial ladder, they get resolved and settled.
Yes.
You may not be satisfied with it, but that's man's judgment. And so if you get to the Supreme Court eventually and the judgment is pronounced one way, there's nothing you can do. In the case of Peter Side and Wiki, the two tribunals ruled one way, the Supreme Court ruled another way. So that's man's judgment. If you are dissatisfied with it, there's nothing you can do. You just take it in your stride. And I think that Nigerians should learn more to be patient with the judicial process.
Join us again after the break.
Nice question.
Angela, that's a great question.
It's a good question.
It is difficult to respond to that question.
That is a serious question. Angela, that is a very great question.
Great question, Angela.
Angela, that's a very difficult question.
That's a great question, Angela.
Okay, that's a great question.
Angela, that's a tough one for me.
That's a good question. Good question.
I love to ask questions. I think it's what I do best. You see, I think that the fastest way to learn anything is to ask questions. The right questions that help you get to the heart of the matter.
60 Minutes with Angela. Again, answers to every question you always wanted to ask.
Welcome back. If you've just joined us, it's 60 Minutes with me, Angela Ajetomobi. On my hot seat today, JITI Ogunye, senior partner with JITI Ogunye and co-legal practitioners. So where are we in the Abia case now? There is an appeal lodged. With the status quo maintained, Governor Ikpeazu continues to be governor.
It appears so because he is the governor there. No new governor has been sworn in. Needlessly, the governor then went to procure an injunction from the state high court restraining the chief judge of the state from swearing in Dr. Oga.
Why did you say needlessly?
Look, we have to have faith in the judicial process. Don't use one illegality to frustrate another perceived aberration. Even if you think that is an aberration, you don't use an illegality to do it. More so when you are charged with the execution of the laws of the state. A governor of a state occupies a special position.
He's the chief
He's
executive.
the chief executive. He's the one that executes all the laws. So if you have three arms of government or three branches of government, the legislature, they make the law. The judiciary interprets. The executive executes. So if you are a governor, it's not just that you are the first man of the state or first woman of the state, you do whatever you like and all that. You have an onerous responsibility of executing the law. So you cannot be a lawbreaker. So when you then go to a high court to procure another video, which no judge ought to have granted.
That's the high court in Osisioma, Abia State.
I'm telling you, just to get a breather. And so this too heavy on me. They are invading me. They want to come and remove me, and all that. So let me go and get an injunction. That was not necessary. He ought to have made the case in the public. this is what I've done.
Yes.
My lawyers are working on this. We'll file a notice of appeal. We'll file an application for stay, and we will go there and argue it. Even if you're going to be removed by an invasion,
Yes.
let the invaders be portrayed as those who are violating the law, not you. For many politicians, they ain't justified the means. Every form of crookery, anything, goes.
As long as they get what they want. Yes, but
they're there.
people listening to us now will wonder, the High Court, who also granted that injunction, first thing is the High Court senior to the Federal High Court?
No, they are courts of coordinate jurisdictions.
Okay.
Although the Constitution divides their jurisdiction. Under Section 251 of the Constitution, you have the Federal High Court jurisdiction. And then, under the same Constitution,
Yes.
you have the High Courts as High Courts of limited jurisdiction and all that.
The lesson I want people to learn from this Abia matter now is that if you're appealing, in addition to your notice of appeal, you probably need an application for stay of execution.
Yes, exactly.
Okay. So let's move on to what many people call immunity. Section 308 of Nigeria's constitution, it's called restriction on legal proceeding, but somehow we all call it immunity. The case of Governor Ayo Fayose of Ekiti State has brought to the fore this debate on immunity. Recall that his bank accounts were allegedly frozen by the Economic and Financial Crimes Commission, and he said, "You can't freeze my accounts because I have immunity." And I thought a lot of people, probably himself, they don't understand what this immunity is all about. So I want you to explain, what does our constitution say in terms of immunity? Who has immunity under our political system?
That question is very relevant, particularly given what is going on and the confusion, again, that is generated in the public domain by commentators and interveners who just inundate us with all sorts of explanations and opinions regarding this matter. Now, under our legal system, we have about 5 types of immunity. We have executive immunity, which Section 308 talks about. That's the notorious one. That is executive immunity. We have legislative immunity, that says that everything that is done on the floor of a parliament, or everything that is written in the motion paper, in another paper, and whatever, cannot be questioned, cannot be subjected to civil action.
Yes.
The exercise of the power of a Senate president or speaker, for example, on
The
that
floor.
seat on the floor,
Yes.
division of votes, ruling on motions cannot be subject to civil action. Placing members in committees and all that,
Yes.
those are not things that you can subject. It's covered by the Legislative House's Powers and Privileges Act, which is the law that governs legislative immunity, otherwise called legislative privilege. That's legislative immunity. We have judicial immunity. And many people don't know this.
Yes.
That says that you cannot, for example, sue a judge for judging your case badly. You cannot sue a judge for negligence. So if that judge is now found to have breached his oath of judicial office,
Yes.
if not received bribe, if he's not abused his office, as to make him answerable under the criminal law,
Yes.
for that, you cannot sue him. So he enjoys judicial immunity. Of course, we have diplomatic immunity, and we know what that means. And
Yeah.
we also have sovereign immunity. I'm just saying this for us to know that
Different
under the legal
ones,
system,
yes.
we have different type of immunity. But talking about executive immunity under Section 308, which provides that the president, vice president, governor, and deputy governor, during their tenure of office,
Yes.
cannot be sued to court. No civil or criminal action can be instituted against them, and that during that tenure, they cannot be compelled by civil summons or criminal summons to attend a court, either as a defendant or as a witness. And more than that, by the interpretation of that provision,
Yes.
if somebody had a case in court as a claimant or a defendant,
Yes.
and then later he became a governor, from the moment he became a governor and then put on that cloak of immunity or that toga of immunity, that case will have to be discontinued, because he can no longer be going to court as if he was somebody who was not covered by immunity.
Can the case be revived when your term ends?
Exactly, to be revived. And then for the purpose of reviving it, for the purpose of counting the time within which you have brought the action,
Yes.
the statute of limitation will not apply
For those 4 years?
For those 4 years. They won't apply. They won't apply. Okay. So the law covers that. But bringing this down to what we're witnessing now in the state, I will also be similarly guided, because I understand that the matter is also taken to court now. My own understanding is this. In the Faroshe's case, what are the facts that we know? The facts that we know, which are not being contested, are as follows. One, the FCC claims that certain monies belonging to the federal government from NSA office, were brought in cash and deposited in a bank, and from there, it was being funneled into the private accounts and of Governor Ayodele Faroshe, and then his company accounts, or the accounts of the company where he has huge interest with the wife. And so they trace these proceeds of crime, so to speak, into those accounts. And that those monies are their targets. They are not targeting governor as a person who is covered with immunity. It is the money they are targeting. And Governor Ayodele is saying that, look, everything that I have is covered by immunity.
If I have immunity, my money has immunity.
My money has immunity.
Yes.
My car has immunity. My dog, has immunity. Everything about me has immunity. My hotel even has immunity. That's what is contained. And some lawyers are saying that, yes, he has that immunity. I don't think so. Because in a typical action by the FCC to recover money under Section 34 of the FCC Act, what is done is that a motion ex parte is taken to a court to procure an order permitting, authorizing the chairman of the FCC to write to a bank and order the bank to freeze monies that are suspicious in those accounts.
Right.
Now, people have wondered if that's what was done in this case. Wouldn't Governor Ayodele Faroshe have been made a defendant, albeit the motion preceding the order that must have been obtained was a motion ex parte, which was not served on him, which does not request him to attend court, so thereby not violating the provisions of the Constitution. But the mere fact that that motion bears his name, would that mean that an action has been technically instituted against him?
Yes.
Then mean that the provision of the Constitution which forbids the institution of an action against him has been violated? Again, I say not necessarily so. And that's why before one spontaneously, dabbles into the matter, understand all the issues.
Yes.
When you want to freeze the money in the account of a person and you want to obtain an order ex parte in court against that person need not be the defendant. Indeed, Section 34 is worded in such a way that the order will be directed to the bank or its managing director or the officer, superintending over that bank. So in that case, what you then have is Federal Republic of Nigeria, because the FCC sued in the name of Federal Republic of Nigeria, doesn't sue as CFCC, versus Zenith Bank of Nigeria. And that's how it works.
This scenario.
And so a government that is covered by immunity is completely taken out of the picture, and then that bank is directed to freeze that account. As a matter of fact, there are similar provisions in Bank and Other Financial Institutions Act, which in Section 36 allows the central bank governor to direct the bank to freeze monies found in a bank account that is suspicious. So it is a special power granted our institutions and a special jurisdiction granted the court to freeze such money temporarily or permanently. It has nothing to do with whether somebody has immunity or not. And as a matter of fact, may the day never come in this country when it will become a rule of law that once any money is found in the account of a governor or a president or a deputy governor or vice president, any money at all, which patently may be proceeds of crime, that money should be treated with awe and reverence.
Yes,
because it enjoys immunity. Once you make that a rule of law, what that will mean is that a governor of a state, once the federal allocation comes, can just corral the commissioner of finance and the accountant general of the state who signed the check and say, you know what, divert all the money
to my
private account. I spend the money on behalf of the state. So the day of Bakizuo, where you keep government money in government house, will no longer be that. Just wire everything to my own private account. And so he has a legislation that is not going to impeach him and he's continuing to spend the money, so we can't do anything. Possibly, other illicit money, including terrorist money, can find safe haven in such accounts. And so, if United States or any other country is saying that, no, we are tracing money into your country, it has gone to certain account, they say, sorry, under our jurisdiction, this money is enjoy immunity, we can't do anything. Drug money will fight. I'm telling you,
yes.
Because some people can be criminally ingenious. So I think that is stretching this immunity thing too far to then suggest that investigation must not be conducted, because what the EFCC is doing is part and parcel of investigation. Yes. They are not prosecuting yet, and that if illicit money is found, question cannot be asked. If question is asked, as it's been done, what that governor or president or deputy governor then does, the duty on his shoulder, the onus on him, is to then go to that court. In that case, the issue of is not instituting an action will not be there. You can institute certain actions that are personal actions, and then say, oh, this money that has a history, my legitimate earnings have been frozen in a bank account. Why should this be so? And then demonstrate to the court how that money is his.
Yes, legitimately.
Yeah. The court will remove that freezing order, and he can adjust his money. But for you to just say, oh, immunity, and then to blackmail the system and blackmail everybody, to pull back so that you can continue to enjoy the money, dissipate that asset before the end of your tenure, is not something that is acceptable in any decent society.
Will this...
And the law does not even support it anyway.
So this style, let me use that word, that the EFCC has used.
It's not a style, it's what the law allows.
It's what the law allows.
Yes.
Will it also work if the person is not political? That is just an ordinary businessman now, not a governor, not anyone who enjoys such immunity.
Exactly.
Will it be the same way?
It will work. But in addition to that, there is section 28 that says that person may be arrested. Once he's arrested, you start preserving the assets so that you will not dissipate the asset, houses and all. That's why a lot of houses now are temporarily seized, so that the person who perhaps is engaged in money laundering does not change the character of that money so much that
you can't identify it
becomes difficult. That's the purpose of that order. So for the ordinary person, yes, you have section 34, you have section 38, when that person is arrested and all that, EFCC can approach the court, as is done in this case, and still obtain an order that we've arrested the person, but now give us an order to freeze his money, and then an order of temporary seizure of his assets and all that. And once that prosecution continues, if the court finds at the end of the day that those assets were illegally acquired, the court will forfeit it to the Federal Republic of Nigeria. If the person is even released on technical ground, and the court realizes that this money now, but on technical ground is being released, the court will not remove the order seizing the assets. The court will still
keep the order,
and then the court can still have the assets forfeited, even though he's not been convicted. All these are in the provisions. All these are in the FCC Act. So many people do not understand the way the law works, or who are biased, or who are being hired to talk in the public domain because they have a voice, because they are regarded as public opinion molders. Immediately something happens like this, like higher guns, they go on there and start saying, and that is not right by the public. If, as a lawyer, I'm hired to pursue a matter, and then people treasure me and treasure my views in the media, invite you to come and talk about this, I will say, no, I can't talk on it. I will decline. Because that means you are manipulating the public. You don't have that right to manipulate the public. And it has its cost, because you think that the public does not know. People know. And so it's important that even while we discharge this public service of enlightening the public and all that, we not take the public for granted and just assume that, oh, we can tell them anything. They will accept it since I'm the one that is saying it. No, it doesn't work like that.
Join us again after the break. So what is 60 Minutes with Angela all about? It's not an interview. I like to think it's a conversation between two people making the news, people who are in the news, and those who become the news. And the whole idea is to inform, to educate, or to clarify, as the case may be. It is an art getting people to answer the questions that everyone is thinking in their minds. And that's what we try to do on 60 Minutes with Angela. I ask all the questions that everyone's thinking about and no one wants to voice. All the questions you always wanted to ask, you get those answers on 60 Minutes with Angela every week on this station. 60 Minutes with Angela, getting answers to every question you always wanted to ask. Welcome back. My concluding moments now with JITI OgUNYE, Senior Partner, JITI OgUNYE and co-legal practitioners. Now, the National Assembly, people are exasperated with these powers they have to summon people. They summon the Attorney General of the Federation, they summon permanent secretaries. I mean, people say even if you have a civil altercation with a member of National Assembly, you may be summoned to come and answer questions. Is there no limit to this right, if the right exists?
You know, the National Assembly recourse to that power of public investigation is a power that ought to be judiciously used. But what we've seen is that even at the drop of the hat, you see the National Assembly resorting to this. And the situation is not helped because there is automation of committees in the National Assembly, both in the House and in the Senate. In the Senate now you have about 63 or 60-something committees. In the House you also have so many. So, and since these committees are there, thinking that they have to work,
yes,
so they have
seem to be working.
So you can imagine if 63 committees conducting hearings, so many people every day and all that. So it's a bedlam. And that's when we talked about using power responsibly.
Yes.
People don't understand why we say so. Because if they don't do so, then they infringe on the powers or on the rights of other people. So it becomes unwieldy, just to start with. But the critical question is, are there limits to these powers? Or that these powers are there and there are no limits? National Assembly, through their committee hearings, does the National Assembly have the power to just summon anybody anyhow and all that? Of course not. And the court has resolved this matter, the case of Tony Momo and the Senate. And the court did a beautiful job, beautiful exposition in that judgment, stating that these powers of summoning people relate only to powers that you have if you are investigating a member of the executive in its official capacity, or you want to make laws, and in the course of making those laws, you want the view of the public to be reflected, you want to hear from them, and so you summon them to come and all that. But what we've seen is that this power has been abused. In our case law, you've had instances where the courts have nullified the decisions and resolutions of the committee of the National Assembly,
yes,
either the Senate or House of Rep,
yeah,
after an elaborate hearing
has been held,
had been conducted,
yes,
legislative time had been spent, and money has also been spent. Sometimes people wonder whether there is not more to it than meets the eye. Is this an extortionate strategy? Is this done in good faith? Is this done out of sheer ignorance,
yes,
of where people should start their legislative work and where they should stop? Or is it done out of excitement or out of
to be seen to be doing something?
To be doing something, grandstanding, legislative grandstanding, or to browbeat even the member of the executive? Are they competing with the executive? Even over one other matter recently, a matter was filed in court, and then they said, we are summoning the Attorney General. Come and tell us why you filed the action, why you exercise your power under the Constitution, under Section 174.
So in other words, the only right time they can summon you is if summoning you is in furtherance of the duty to make laws.
And then they are investigating corrupt cases. But even at that,
yes,
which is very important, because people just say this without putting everything in proper perspective. Since the evolution of those provisions, because those provisions were lifted from the 1979 Constitution,
yes,
and then we find them in the 1999 Constitution. What have we had? We've had specialized agencies dedicated to combating corrupt practices in government. The ICPC Act of 2000, the FCC Act of 2002 and 2004, apart from the Code of Conduct Bureau. In other words, the point I'm making is that job of exposing corruption that you think the Constitution says that you should be, investigating,
yes,
you now have specialized agencies specially created to do that job. And mind you, because your report in the Senate is not a substitute for an investigation report
Yes.
of the police or EFCC and all that. They cannot be used to try any person. So what you then have is that,
What is the aim?
what is the purpose? So if you do it, you hand it over to the EFCC. EFCC then says, okay, we'll now start to do our own investigation, because you have to take a statement. You have to do the caution. You have to fulfill all the
Follow all
procedure
the steps.
for, investigation before you can even commence prosecution. So it's like grandiose but hollow duplication of efforts. So when people say that, yeah, they are exposing corruption, I say, yes, should that take the place of their basic duty of legislation? So if indeed our legislators are now redundant, shouldn't we be looking at the possibility of a unicameral legislature? Should we be making this a part-time thing now with the ICT and digital age?
Yes.
So that when you sit in your house, if you have processes, you don't have a secretariat. If a bill is brought and all that, it can be sent to all of you. You read it and then you
Make your
converge
additions or
and
whatever.
all that. And it's like teleconferencing. So why can't we look at that? So rather than just, generating hearings, torment people, because you see, you really need to know what is going on, which nobody is going to come on national television to say.
Yeah.
When they come in to say that they are performing their oversight functions or whatever, those agencies receiving those legislators will have to provide money.
Cough up.
I'm telling you, to fit them, to receive them.
Logistics.
I'm telling you.
Okay, so anyone watching now, are you saying that if I hit the car of a senator or a member of the house, or I make a comment about them, they can't summon me, I can say no, I won't be arrested?
Yes, and then you wait for them. So if they give that summons, or you go to court,
Yes.
just as Tony Mama did, and said, look, they want to abridge my right to liberty. I've exercised my fundamental right to freedom of speech.
Yes.
Even if that's what it is, I've abused a senator and they are inviting me to come and appear. This is an infringement of my fundamental rights to freedom of speech, and now they want to compound that infringement by abridging my right to liberty. So stop them from doing so, and I have no doubt in my mind that the court will do so.
And finally now, to this matter of self-determination. We've seen a lot of ethnic groups or ethnic nationalities coming up within our Nigerian space to agitate to secede from the Nigerian state itself. Is the matter of Biafra still going on? I've seen some people even coming with Oduduwa Nation. So I wanted you to explain what this right to self-determination is. Where does one draw the line before it becomes treason?
Classically the right to self-determination and the other one, the right of colonized people to govern themselves, formulated by the United Nations, are essentially meant to aid the aspiration of colonized people in colonized territory during the period or era of colonization, so that they could then gain independence.
Right.
Now, it is true that because those principles still remain, people time and now resort to them even within nation states and independent countries to agitate for their own independence within a state. And so it's not just in Africa that you still have people saying that. You have people saying that as we speak in northern Iraq and southern Turkey.
Yes.
The Kurds who want to carve a state for themselves. In Spain, you have people saying that.
Yes.
And so in Nigeria, people have recourse to that time and again. When there is a crisis like this, and people start advising government, negotiate with them, don't use force. I look at that and say that, so will the Nigerian state be engaged in perpetual negotiation forever?
With everybody.
Not with everybody, every time when there's a crisis, because we are really in crisis,
Yeah.
and it may take a long time before this crisis will be over. Why can't you just have one grand ecumenical conclave, a conclave of many people, a rainbow conclave, so to speak? Bring all our people together, let's discuss, so that we then have the protocols that will undergird our federation and our living together, rather than then having these occasional discussion with the group. So when you discuss with them and you engage in what I call propitiation and appeasement, then they agree with you for a while, they strengthen themselves, acquire more arms, become more moneyed, even build universities for themselves and do all sort of things.
Yes.
They've also become a property class, and they are in a position to now wage even a more ferocious war
Yes.
against the state. You're not going to get out of it. And so I ponder, if armed robbers were to have an association, and I'm not saying this lightly, or kidnappers, and they can hold the Nigerian state by jugular.
Are we going to negotiate?
Are we going to be negotiating with them? I support a conference. We've not had it. We've had a facade of that discussion. Even the last one, where the former president just unpicked his friends and some other people and said that this is the conference. That's not the conference. So we still need to have that. I support that. But the idea of, even if you buy yourself some space, a government can adopt an attitude. My tenure is 4 years. I don't want trouble for myself.
Yes.
I want to postpone the evil day for Nigeria. But I want to have a peaceful reign. Let me cut a deal with these people. They want amnesty, okay, give them the money. I've reduced their money from 60 billion to 20 billion and they're agitating. Let me give them the 60 billion and all that. I just want to stay here. You can adopt that attitude. It may not have any cost for you as a president, but it will be very costly for Nigeria. Because we are by and by agreeing that Nigeria is going to become a state of rogue organizations who can confront the state and then, blackmail the state into winning concessions. And so the ordinary way of doing things prescribed by the rule of law of resolving disputes become trumped in favor of emergency negotiation and then striking a deal and compromise with all sorts of people and all that. And I think that will be costly for the Nigerian state. If you want the Nigerian state to wither away, not in the Marxian classical sense of the state withering away at the highest stage of communism and all that, but a state where criminality is rife, brigandage is open, and corruption is pervasive, law cannot be maintained, order is absent, that state will wither away eventually. So if that's what you want, and you have this kind of nibbling at the state esteem and prestige, maybe you won't mind strike a deal there, the state becomes weaker and weaker and weaker until the state will become irrelevant in the scheme of things. But for people who think that we can manage our affairs as a country under the rule of law with the rights of each and every one and each and every people being respected under a truly federal arrangement where constituent parts take control of their resources and then remit tax to the center, as it was done between 1960 and 1966, when the military, when they were fighting a war of unification of Nigeria, started distorting the revenue formula of Nigeria and concentrating powers in the hands of the center. If you go back to that era and then you renegotiate, even determine how many states we should have, what is the advantage and value of a state that cannot even pay salaries for its workers? We then have these states that cannot function. So how did we get here? 36 states, one country, 170 million people, 36 states. What do we need this state for? And many are still agitating for those states now. Badagry State, New Lagos State, Okeogun State, Ijebu State, Oduduwa State, and all sorts to create fiefdoms and territory for power elite to hold their ground, say that okay, this is my own backyard, as is said in the common parlance, this is my own hood, so I'm the Lord and Master here. If that's not what we want a state that can really function with units that are viable. Shouldn't we have this discussion? Because the state will not negotiate themselves out of existence anyway. The legislature and the National Assembly who are pretending to be amending the constitution will not negotiate their state out of existence or negotiate their territory out of existence. So we need a special body that can do the job in a very dispassionate manner, because people there won't have vested interest. They won't be legislators who will say, if I say that my state should be consolidated and cancelled, then the senatorial district in the state will shrink. So I won't be here now. So it's not given unto man to remove privileges and advantage from himself. So you need that body to do it. So if we favor that, one superb conference, yes. But if what we just want to do is to be negotiating, cut a deal today, tomorrow we are in trouble, just be reeling from trouble to trouble. Well, we may cut a deal. We may have an amnesty, so to speak. We may have people not blowing the pipes. We may generate crude oil revenue and all that. But once we are out of that problem, and that problem is going to confront us ahead of us, because we are going to have mutations.
Yes.
And this also, we must say, a reflection of the season of anomy in which we find ourselves. Opportunities are shrinking for our people. Power elites are grabbing all the resources,
Yes.
including lands and all that. And so people are out there, the unemployment rate is high, schools have been destroyed, healthcare delivery system is comatose, social provision is nothing. So our people are going to all the remotest parts of the world to look for education, Ukraine, Georgia, all over the place to look for education, even places like Ghana and Togo, we are going there to look for education. Our people are dying in India, all sorts of problems. So the state cannot perform the function of a vibrant and beneficial state. And so some of these reactions are coming. So we understand that. But the way to resolve the problem is not to be cutting a deal with the devil. Each time the devil, scares us.
Yes.
And then we then say, okay, let's just discuss and then have those palliatives and then think that we are governing a state. No, that's not how it goes.
Thank you very much, Mr. Ogunye, for coming on 60
my
Minutes
pleasure.
with me. And thank you for watching. I'm Angela Ajetumobi.